One of the most frustrating parts of learning probate litigation was that everyone kept using words as if I already knew what they meant. Trustee, beneficiary, executor, administrator, petitioner, respondent. The judge used them, the attorneys used them, the court papers used them, and I was expected to know who everyone was. If you are new to probate litigation, let me introduce you to the people you should know too. Let's start with the trust. The first person is the trustor, sometimes called the settler. This is the person who created the trust. In my case, that was my mother. The next person is the trustee. The trustee manages the trust and is responsible for carrying out its instructions. While the trustor is alive, the trustor often serves as their own trustee. After the trustor becomes incapacitated or passes away, a successor trustee typically steps in to manage the trust. In many probate disputes, the trustee is one of the most important people because they control the trust assets and trust information. The final person is the beneficiary. The beneficiary is, in essence, the person who receives the benefit of the trust. Now let's move to the estate side. The first word is decedent. This is the legal term for a person who has passed away. Before death, the court documents may refer to them by name or by their role in the case. For example, if they created a trust, they may be called trustor or settler. After death, they're often referred to as decedent. The next two words are executor and administrator. These people perform similar functions. They manage the estate. Generally speaking, an executor is named in a will. An administrator is appointed by the court when there is no will or no available executor. One way I made sense of all these terms was to think of them as belonging to two different worlds. Trusts have trustors, trustees, beneficiaries, and assets that have been transferred into the trust. Estates have decedents, executors or administrators, heirs, and assets that remain in the decedent's name. That's an important distinction. Assets inside a trust are generally managed through trust administration without court oversight. Assets that remain in the decedent's name are managed through probate administration, often requiring court oversight. Finally, there are litigation terms. The petitioner is the person who files a petition asking the court for something. The respondent is the person responding to that request. In my case, my siblings and I were the petitioners. My brother was the respondent. When I first entered probate court, I had never heard either word. Now they seem completely normal. At first, all these words were confusing and felt overwhelming. But once I understood who the people were, I could start to see how they fit together. And once I understood how they fit together, the process became much clearer. The next step is figuring out where you stand in this whole process and whether you have a probate case. If you're ready to take that next step, take my free quiz, Do I Have a Probate Case, in the pinned comment below. The quiz will help you think through questions about standing, deadlines, and legal grounds. You'll also receive my free evidence checklist to help you organize your facts and evidence.